Well, welcome everyone. It's my very great pleasure to be welcoming you to, I think, the last CIPIL research seminar of the term, and really great pleasure to welcome Dr. Peter Coe, who's a lecturer at the University of Reading, editor-in-chief of Communications Law, and the convener of the Media and Communications subdivision of the Society of Legal Scholars, all really fantastic activities. And more to the point, for this evening's session, he's the author of a fabulous new book on a really important topic, a topic dear to my own heart, which is the media, but also what do you do in relation to the growth of citizen media, citizen journalism, and where does media regulation and media freedom fit into that new world? Obviously bringing up issues of privacy, reputation, defamation, also contempt of court and issues like that. So really delighted to be welcoming Peter and welcoming him, albeit only virtually, but to talk about his really fascinating and interesting new book. So without any further ado, there will be opportunities, by the way, to ask questions. Do put them in the chat. If you want to be anonymous, I think there's an anonymous button. Otherwise, I may call out your name. But without any further ado, here is Peter and his presentation.
Thank you very much, David, for that introduction. I really am very grateful for the invitation to be here, so thank you for that. I'll just share my screen with you all. Just bear with me a second. As I said, thank you to David for inviting me to come in and discuss my book with you all this evening. Having a real book in my hand that I've actually written, I have to say, still seems rather surreal to me. I think it's going to take me a while to get used to it. I think what will take me probably even longer than having a real book in my hand is that fellow academics such as yourselves are interested in it and what I have to say about it, and may also read it. Of course, there's absolutely no pressure to do so, but you know, thank you all so much for being here and for taking the time to listen to me and to listen about my book. It really does mean an awful lot to me. So as David said, I'm a member of the School of Law at the University of Reading. I'm also an Associate Research Fellow at the Institute of Advanced Legal Studies and the Information Law and Policy Centre. If you want to get in touch with me at any point, my email address is at the bottom of the screen, and I'm also on Twitter as well. So please do feel free to reach out if you have any questions about anything that I talk about this evening. So before I forget, I probably should plug my book launch, which is going to be hosted by the Institute of Advanced Legal Studies at 9 AM on the 11th of May. It's going to be a virtual event, and you can sign up to the event either by going onto the Institute's website or by following this link on the slide. I'll send these slides to David after the session. It's going to be a panel session, so I'm going to be joined by Professor Paul Wragg and Rebecca Musavian from the University of Leeds, Professor David Rolfe from the University of Sydney, Professor Andras Koltai, who is the president of the Hungarian Communication and Media Authority, and also Lexi Kokonel-Kowana, who is head of regulation at Impress. And indeed, if you know anybody else who'd like to attend, then please, do let them know about it. As I said, I'll pass these slides on to David after this is finished. Now, I'm going to split this talk into three parts. I'm going to begin by explaining what motivated me to write the book and why I'm so fascinated by the press and also by citizen journalism. And in the second part, I'll set out an overview of the book and its claims. And then finally, I'm going to discuss the impact that my research and my book is already having on press regulation in particular. So, this book is based on my PhD thesis that I completed at the University of Leeds under the supervision of Professor Paul Wragg and Professor Alistair Mullis in 2019. However, my long-held fascination with the media, in particular the press, and the role that the press and journalists play in public discourse and in democracy, and the power and influence they have over us as members of the public, goes back way before I even contemplated a PhD. In fact, it goes way back before I even contemplated being a lawyer. If I'm honest, there's a link to one of my other passions in life, which is sport, and in particular football. When I was doing my A-levels, I wrote a report on modern day press and media barons such as Silvio Berlusconi and Rupert Murdoch, and their ownership of football clubs, or in Murdoch's case, his attempted ownership through Sky B of Manchester United, and what that meant for the public sphere. So little did I know it then, but the seeds for my research and eventually a PhD and ultimately this book was sown when I was watching Football Italia and Match of the Day as a teenager, albeit, as I'll explain, my focus has shifted somewhat from media moguls playing with football clubs to a new breed of journalist who is having a profound impact on the public sphere. So fast forward then, and I hate to say this, the best part of 25 years. And as I say in the introduction to my book, journalism has changed. The internet and social media have permanently altered the media ecology and have shifted the media paradigm beyond recognition by enabling new actors in the form of independent publishers and citizen journalists to enter the media marketplace, and by changing the way and the speed in which news is generated, published, and the way in which we as the public consume news. On the one hand, as I say in the introduction, these changes have had a profound impact on the viability of the traditional institutional press, and on the extent to which journalists operating within the industry's typical corporate institutional structure are able to discharge their watchdog role and contribute positively to public discourse and to the public sphere. In ways that I will explain later in this talk, the internet and social media have contributed to the pressures that are generated by corporate ownership of the institutional press. These pressures encourage journalists operating within this structure to publish content that appeals to mass audiences and attracts advertisers, rather than engage in high quality, yet expensive and time-consuming public interest journalism. On the other hand, however, as I say in the book, the internet and social media do not only remove the technological and financial barriers to producing and disseminating content by allowing anybody, in theory at least, with internet access to communicate instantaneously with a mass audience, they also enable journalists to circumvent the structure and some of the norms of the institutional press. And in a sense, they liberate those journalists from some of the constraints and pressures imposed on the press by the dominant proprietor and corporate ownership models of press ownership. Consequently, there is an argument to be had that the internet's dismantling of these obstacles has contributed to the democratization of the public sphere, by making the emergence of more voices in the public space possible. And this is a contention that is animated by the ascendance of citizen journalism. Indeed, it's a central claim in my book that citizen journalists are no longer an outlier of free speech. Rather, they are central to how we communicate. It's this change in the media ecosystem and the shift that this has caused in the media paradigm, and what this means for our understanding of free speech, press freedom, press regulation, and for laws relating to, for instance, defamation, privacy, contempt of court, and how we manage online anonymity and pseudonymity, which really fascinates me. This is therefore the core motivation for not just this book, but my ongoing research. So before I discuss with you what, in my view, this all means and the claims I make in my book, I want to explain briefly what I mean by citizen journalism and why citizen journalists, I think, are important. So the origins of citizen journalism can be found in the civic and public journalism reform movement of the late 1980s. They're not a new thing. This movement which aimed to encourage public interest and participation in public affairs, advocated that news media should go beyond the mere reporting of information to act as a catalyst and as a forum for the revitalisation of democracy. Despite these early origins, however, it was the internet, and in particular the emergence of social media, that really provided the means for journalism to be opened up to citizens. Because of the wide spectrum of activity that citizen journalism covers, it's not easy to define. At one end, at its most primal and crudest, it could be an individual providing some sort of one-off content or event that contributes to public discourse. However, for some of these bloggers, this can trigger, and indeed it has triggered, the beginning of a journey in which their journalistic activity becomes increasingly professionalized and important to the public sphere. So at the opposite end of the spectrum, at its most sophisticated, citizen journalism can include actors operating outside of the institutional media structure, really as professional journalists in all but name. And it can arguably even encapsulate actual professional journalists blogging in an individual capacity rather than part of the institutional press and broadcast media. And indeed, something that I discuss in the book is how job cuts in the press industry have actually led to a growth in independent journalists who then compete with their former employers, which can in turn further undermine the financial viability of the press. Now, citizen journalists at this end of the spectrum contribute to the robustness of the public sphere in a myriad of different and impactful ways from countries all over the world. For instance, the blog Nightjack, which I discuss in detail in the book in the context of the author of a blog and Times Newspapers Limited litigation, won the 2009 Orwell Prize for Citizen Journalism. The blog's author, Richard Horton, was a serving police officer who used it to pseudonymously discuss his work and criticise government ministers and police operations. Now, according to judges who awarded the prize to Nightjack, they said the blog content provided a valuable insight into the everyday life of the police, which took the audience to the heart of what a police officer has to do. Similarly, the content produced by the political blog Guido Fawkes, which is authored by Paul Staines, has also been the subject of significant critical acclaim. And the blog's extensive reach was the subject of evidence presented to Lord Justice Leveson during his inquiry into the culture, practices, and ethics of the press. Arguably, the positive impact of citizen journalism on the public sphere is perhaps most obvious in times of conflict or in crisis situations. And we saw this during the COVID-19 pandemic, certainly where people were reporting from countries where perhaps the press isn't as free to report on the real state of what was going on with the spread of the virus. And of course, we are seeing it now in the conflict in Ukraine. We have citizen journalists who are reporting on the ground in areas where perhaps it's too dangerous or even inaccessible for professional journalists from the institutional media to actually get to. And in fact, very often the institutional press relying on the information that's being conveyed to them by citizen journalists in those types of situations. Citizen journalism has also helped to make the institutional media more transparent by virtue of blogs such as Jim Romanesco's Poynter Institute Media News, that in his view, it has to be said, is what he's called it a water cooler, not just for journalism, but for people who observe journalism. So in addition to acting as a public watchdog by producing diverse and important public interest content, citizen journalists are performing another vital democratic function. They're making professional journalists and the institutional media more accountable by exposing unfair, inaccurate, or just poor quality reporting. So, To give you a sense of how the book is structured, it's divided into 3 parts. The first part looks at the media landscape. In the second part, I look at theoretical considerations. And in the final part, I deal with some of the legal challenges that the theoretical concept I advance in the book, I think can help to deal with. Now, I should add at this point, I'm going to give you a whistle-stop tour of the book. I obviously can't go into a huge amount of detail on each section because we'd be here all evening. As much as I'd love to talk about it, I know everybody else probably has better things to be doing than listening to me. So I'm going to give you an overview of what I say in each of these 3 sections. So, although I've spent the last few minutes talking about how the internet and social media have permanently altered journalism, I decided to begin the book by taking a step back, by looking firstly at the institutional press and then its relationship with the internet and social media and with citizen journalists. These opening 2 chapters, which form part 1 of the book, provide a foundation for the arguments I advance later on. And incidentally, I should say that these 2 chapters were not in any way part of the research I did for my PhD, but I have to say that I thoroughly enjoyed writing them. They provided me with a wonderful opportunity to spend time looking at every aspect of the press as an industry, from its origins to its ownership to how it is run and financed. And I do this on a timeline from the creation of the printing press to what the industry and the profession may look like in the future. And I have to admit, it also gave me an opportunity to put something in my book about Silvio Berlusconi and Rupert Murdoch and their relationship with football. So I think maybe I was trying to claw back some of my youth through this book. So the book begins by asking whether the concept of the free institutional press is a fallacy. And in doing this, I analyse the common ownership models of the press, both historically and currently. The thrust of my argument is that the dominant proprietor and corporate ownership models, which are the 2 most common models of news media ownership, pose significant challenges to democracy, and they lend support to the claim that the notion of the free press is indeed a fallacy. Arguably, the fact that the model's commoditization of news has created a commercial necessity for treating audiences as consumers, and therefore a bias for giving audiences what they want rather than what they need as citizens, has created a democratic deficit. As opposed to being organs for journalists to discharge a watchdog role and increasing access to the public sphere by acting as conduits for different groups within society to express their views, large parts of the press and the news media generally are owned by a relatively limited number of individuals or by multinational conglomerates, meaning that journalists are often constrained by corporate shackles such as the whims of owners or the need to generate profits for shareholders or to appease advertisers and commercial partners. Now, in the chapter that follows, I build on this discussion, and specifically I consider whether these democratic challenges in relation to the institutional press have or can be overcome by social media and its facilitation of citizen journalism. In doing so, I ask what the barriers are to social media and to citizen journalism, increasing access to the public sphere, and where the challenges may lie in the future. Now, in summary, I suggest that although it's clear that some of the early predictions for the transformative effect of the internet and social media on the public sphere have turned out to be pipe dreams, they have undoubtedly caused huge changes to the media ecology. As a result of our transition from print to online news consumption and the commercial pressures that this has generated, much of the traditional institutional press is in a perilous financial position and is unable, or perhaps in some cases unwilling, to contribute to the public sphere in a way that conforms with its, certainly the perception of its public watchdog role. The way in which social media platforms operate add to this problem, by distorting the public sphere in other interrelated ways that can inadvertently impact upon the ability of all types of journalists to positively contribute to public discourse. Now, in my book, I focus on three of these, which are firstly, the online aggregation and distribution of content by digital gatekeepers. Secondly, user preferences, the creation of trends, and the creation of filter bubbles. And finally, misinformation and disinformation. Now, each of these could easily take up an hour, so because of time, I'm only going to provide a sketch of the first one of these. So the online aggregation and distribution of content by digital gatekeepers. The reason for this is it impacts on the other two. So I'm gonna look at that one rather than try to get through all three of them, probably unsuccessfully in the time I have. So although we as a public are increasingly going to multiple sources for our news, this does not tell the full story. It masks a problem for the public sphere because it is often achieved through platforms operating as news aggregators, such as Google and Facebook in particular, who effectively filter the news we see by algorithmically pulling together content from multiple news outlets to disseminate via their own platforms. In this sense, these companies are operating as gatekeepers, as although the content that's disseminated through their sites is controlled by algorithms, which also determine how prominently those particular stories are displayed, the algorithms are programmed by a human editor who is likely to be working towards commercial goals as opposed to professional journalistic standards. Thus, the process of news distribution by platforms is not a neutral or value neutral activity. Rather, it's likely to reflect the business and ideological interests of the respective platform. Now, in itself, this isn't necessarily a problem. However, when considering that most users will be unfamiliar with the underlying interests and values of the particular news aggregator they're using, combined with our increasing reliance on them, which means we're less likely to see content we're not shown, it presents, in my argument at least, an opportunity. Platforms may also adapt rather their news feeds in line with their ideology, particularly their social and political objectives. And we've seen high profile examples of this from the likes of Facebook and also from Google and Apple, who've been criticized for engaging in ideologically based content selection. And a great example of this is the Facebook 2016 trending topics scandal. Gizmodo reported accusations made by former Facebook employees that conservative topics, and bearing in mind this was during the 2016 US presidential election when Donald Trump was elected. So they reported accusations made by these whistleblowing employees that conservative topics and sources had been deliberately and systematically suppressed by the platform, with staff being explicitly instructed to select topics based on these political considerations. Now, specifically, Gizmodo's report alleged that links to certain conservative websites were not allowed in the platform's now defunct trending topics section, despite them being amongst the most frequently shared content on the platform. Now, the allegations made in the report directly conflicted with the platform's previous claims that the content of trending topics was compiled by algorithms and was determined solely by user activity rather than with any human intervention. Now, the scandal provides evidence for badly kept secret, namely the transition of platforms such as Facebook and Google from technology companies to actual news editors, akin to the institutional media. In doing so, it demonstrates that although the owners and leaders of these companies may exercise their own free speech, by doing this through their platforms, very often to their own ends, they have the power to significantly distort the democratic public sphere by, for instance, exerting direct political influence through the manipulation of our news consumption using obscure means based on opaque ideological principles. Ideological neutrality, I say in my book, is a fundamental requirement of a healthy and functioning democratic public sphere, by surrendering this neutrality to platforms and by embracing their biases, the public sphere can become distorted. Therefore, the non-neutrality of platforms gains a completely new and more sinister quality if the editorial decisions made by platforms that influence our news consumption are value-laden and guided by an ideology, or for the purpose of achieving certain social objectives or business objectives over and above the open discussion of public affairs or a free and democratic public sphere. However, it's not all doom and gloom, because I go on to say in the chapter that, on the other hand, far from just negatively impacting upon the scope of the public sphere, the internet and social media have also brought many positive changes, least of all their facilitation of citizen journalism. Citizen journalists contribute to public discourse and the democratization of the public sphere by providing a diversity of very often high quality content, thereby stepping into the watchdog shoes of the traditional press, and also by being a reliable source of information for the mainstream media. But their ability to make an even greater contribution to public discourse is often limited by their status and their credibility and the trust that's placed in them by audiences. Some of these limitations, I argue, can be overcome or at least alleviated by the application of the concept that I advance in my book, which is called the media as a constitutional component concept. I really did not think about that name when I came up with it. I wish I'd have chosen something shorter, because it's a real mouthful, but there you go. I've had to stick with it, unfortunately. And the framework that this concept provides. And this brings me on nicely to the second part of my book, which is theoretical considerations. So I make the claim in the book that the enhanced right to media freedom attaches to actors defined as media, and that this right is a freedom which serves specific positive goals for democratic participation. Therefore, it affords media entities privileged protection over and above non-media actors. But as a result of this, it carries with it concomitant duties and responsibilities. So I argue, as have many others before me, this isn't new, I argue that there are two categories of free speech: the personal right to freedom of expression and media freedom, and that media freedom ought to be treated differently to freedom of expression. Now, in a world where citizen journalists are making an important positive contribution to public discourse by reporting on matters of public interest, being able to identify the beneficiaries of media freedom is critical to the effective operation of the right. However, I argue that in the current categorization of who belongs to which group, there's a gap, or there's confusion, as there's a definable category of actors who are, as citizen journalists, effectively media, but are not always recognized as being media. This is because the methods that have traditionally been used to define media, and therefore who should be subject to the enhanced right to media freedom, at best lack merit and are at worst redundant. Because of the vital role being played by citizen journalists in the news gathering process and in the publication of our news, both as publishers in their own right, but also as sources of news, this situation, I argue, is really quite problematic. But the difficult situation we find ourselves in here is entirely understood. The dominant philosophical theories that underpin free speech and media freedom are John Stuart Mill's argument from truth, and particularly in the context of online expression, the marketplace of ideas. However, these libertarian arguments are based on 19th and early 20th century means of communication. They are not, in my view, suitable for 21st century speech and the modern media, of which the internet and social media and citizen journalism are central components. Now, as it stands, the law relating to the operation of free speech and media freedom is lagging behind reality. Consequently, the law's treatment of media freedom as a normative concept needs to be modernized, but for the law to catch up, I suggest, so does its theoretical foundations. So what the book does is it offers an alternative normative framework that deals with these problems and understands media freedom within the context of 21st century communication and the legal challenges that this creates, and that ultimately, I hope, would improve the public sphere. So to facilitate this modernisation, I advance a new functional definition of the media that distinguishes media from non-media actors. And as I've already alluded to, I call this the media as a constitutional component concept. This concept is underpinned by social responsibility theory and also the argument from democratic self-governance. Now, I argue that although the conditions created by the internet has meant that libertarianism has become the dominant normative paradigm for online speech, in reality, social responsibility theory provides a more appropriate normative foundation for the modern media. Essentially, the theories differ in that libertarianism dictates that free speech is absolute, and as a result does not propagate duties and responsibilities that attach to the right to freedom of expression and also media freedom. Whereas under social responsibility theory, this freedom carries concomitant responsibilities and obligations to society, to employers, and also to the expression market. This normative foundation provided by the social responsibility theory supports its premise that adherence to certain norms of public discourse, so in other words, the type of speech conveyed by the actor, and standards of professional behaviour, so for example, acting ethically and in good faith, and publishing content that's based on appropriate research, rather than the education, the training, or the employment of the actor, should define who is a journalist. In turn, this functional rather than an institutional approach to defining media determines who should benefit from the right to media freedom and be subject to its duties and responsibilities. Thus, the concepts, norms of discourse, and standards of behaviour create a threshold. Actors operating within this threshold are classed as media and are therefore entitled to the benefits that come with it, whilst those operating outside of it are not afforded the same status and the protection that comes with it, albeit, of course, they're still subject to the general right to freedom of expression. Now, I should add at this point that in making these claims, I argue that although my concept that I've come up with shares similarity with Robert Post's participatory theory of democracy, it overcomes problems with it relating to access to the public sphere. Central to Post's thesis is equality within public discourse, as opposed to fair access to it. Accordingly, everyone who already has access to the public sphere should have equal autonomy, which reflects the political equality that all citizens enjoy within a democracy, so he says. This means that the state should treat with equal respect the ideas and opinions of those already engaged in the formation of public opinion, but it cannot introduce mechanisms to ensure fair participation in it. The scope of free speech protection afforded by Post theory is therefore reduced to those already contributing to public opinion, meaning that it tends to reproduce the inequality that benefits dominant speakers to the detriment of weaker ones. Consequently, his theory is structurally limited to predominantly the institutional media and also now the dominant online platforms, and it excludes groups or individuals who cannot gain or who have difficulties gaining access to the public sphere, which could be citizen journalists. Now, although Post acknowledges the existence of exceptions, they are limited to his recognition that democracy requires only that inequities that undermine democratic legitimation be ameliorated. Thus, this solution is, as John Charney has argued, a circular trap, as the elements of democratic legitimation recognised by Post are reduced to government accountability to and equal autonomy for those who are already engaged in public discourse. Now, this is the point at which Post's conception of participation in the public sphere and that cast by the media as a constitutional component concept that I advance diverge. Unlike the theory of participatory democracy that arguably does little more than maintain the public sphere status quo, my concept is not concerned with the actor having institutional status by virtue of their education or their training or their employment, or because they are already contributing or have previously contributed to public discourse. Rather, it expands the public sphere by normatively securing access to it as media for any actor that adheres to its standards of professional behaviour and norms of discourse, which are equally applicable to all citizens. So, part 3. So, in the book, I suggest that in addition to providing a conceptual framework that improves the credibility of online and pseudonymous speech through its harmonisation of speaker and audience interests, helps to maintain fair trials whilst allowing citizen journalists to access court documents and legal proceedings, and better promotes and protects media freedom in the context of the law of defamation, the concepts, norms and standards also provide the conceptual rationale that underpins a modified regulatory scheme that I advance in the book's final chapter. Now, because of time, and I'm aware I am running out of time, I'm not going to discuss anonymity and pseudonymity, fair trials and defamation. I won't have time for that. You'll have to read the book if you'd like to see what I say about that. Rather, I'm going to give you some of the highlights on what I say about press regulation. And this is because my book and my ongoing research is already making a significant impact on press regulation. And I'll talk a bit about my work with Impress in a moment. So I begin this final chapter by explaining that regulation is important because press malfeasance in relation to both its news gathering and publication activities has caused and continues to cause what Lord Justice Leveson referred to in his inquiry as real harm to real people. Now, as I go on to explain in this chapter, this harm is no longer being caused exclusively by the institutional press. Citizen journalists are just as capable of unjustifiably damaging reputations, invading personal privacy, publishing false news as the institutional media, which means that any satisfactory regulatory solution must surely, I argue, be one that extends to citizen journalists and the institutional press. Now, for reasons I explain in detail in this chapter, the current voluntary self-regulatory regime in the UK is not satisfactory for the institutional press, let alone for citizen journalists. And in a nutshell, this is due to the following reasons. So, firstly, in light of Lord Justice Leveson's recommendations to encourage press membership of a regulator approved by the Press Recognition Panel, which is currently Impress. Impress is the current PRP approved regulator. Section 34 of the Crime in Courts Act 2013 enables a court to award exemplary damages against any relevant publisher in litigation who is not a member of an approved regulator. Now, among the requirements for approved status that are prescribed by the Royal Charter is that the regulator will have a low-cost arbitration system to reduce legal costs for both the claimant and the press. Now, Section 40 of the 2013 Act could be at the core of this regime, this cost incentives regime, as it empowers the court to award adverse costs against non-members of an approved regulator by forcing the relevant publisher to pay the claimant's legal costs, even if the publisher is successful in defending the claim. However, it remains dormant on the statute books, and it seems it's unlikely to be brought into force, and certainly not under this current government. The effect of that is that approved regulation becomes a blunt instrument, as it disincentivizes membership of an approved regulatory scheme, and it ultimately and fundamentally undermines the purpose of approved regulation. What it does is it effectively inverts approved regulation into a self-serving system. So that's the first problem. The second problem is that sections 34 and 40 apply to any relevant publisher. Now, according to section 41, subsection 1, a relevant publisher is a person who, in the course of a business, publishes news-related material that's written by different authors and is subject to editorial control. Section 41, subsection 2, tells us that this means that a person who does not have to be the publisher has editorial or equivalent responsibility for the content and presentation of the material and the decision to publish it. Now, crucially, Section 41 has the potential to exclude a large number of citizen journalists for two reasons. So, first of all, by definition, many citizen journalists are not publishing news-related material in the course of a business. And secondly, citizen journalists tend to be both the author and publisher of their material, as opposed to publishing material written by different authors. And then the final reason for the problem with our current regulatory regime is in respect of the Independent Press Standards Organisation, so IPSO, which is the other regulator we have in the UK, the non-PRP approved regulator. Citizen journalists are only covered by its code if they submit material to the publishers that it regulates. Now, this requirement would seem to exclude most citizen journalists, as the very nature of citizen journalism dictates an inherent tendency to eschew the mainstream media, including members of the institutional press, who make up the bulk of IPSO's membership. Now, in the book, I do talk about mandatory regulation, and Paul Wragg has argued brilliantly and convincingly in his recently published book, for mandatory regulation in respect of the institutional press. But I argue that this doesn't provide a viable alternative for citizen journalists. And in the book, I suggest that it would be unworkable for a number of reasons that I explain in detail there. Again, I haven't got time to go over that now, but it's something you may want to look at if you decide to read the book. So what's the alternative to all of this then? Well, I argue that the concept I advance in the book provides a conceptual framework for a modified regulatory regime, which could, if implemented, be attractive to and also provide robust regulation of both citizen journalists and also members of the institutional press. So social responsibility theory allows for regulation, albeit within a purely voluntary and self-regulatory model. Now, it's at this point that the theory and the media as a constitutional component concept, to an extent, diverge. Although the regulatory scheme that I advance draws on social responsibility values, is voluntary, and would be overseen by an approved regulator such as Impress, it differs to the current blunt regulatory regime, and that it provides statutory and non-statutory incentives and has statutory powers to impose sanctions on publishers that not only go well beyond Section 34 and the currently inactive Section 40 of the 2013 Act, but significantly, I think, would apply and also be attractive to citizen journalists. Now, I won't go through all of those incentives here again because I don't have time, but I just wanted to mention a few of the highlights. So in respect of the statutory incentives, my scheme, the scheme I advance in the book, will firstly contain incentives similar to sections 34 and 40. But the issues associated with these provisions would be remedied, in that the provisions would, first of all, be enacted and be operational. That's the first thing to say. But of course, there is a lack of control over that because of the current government in power. But unlike the 2013 Act, would apply to citizen journalists, as they would capture actors that are operating as the author and publisher of material, and those that are not publishing in the course for business, in the same way as those that are. So it would remedy that defect, which I think is absolutely critical. In respect of non-statutory incentives, I think this is where the regime really comes into its own. And this is where a lot of my work with Impress has kind of taken place, which I'll discuss in a moment. The concern of regulation is, as I said earlier, protecting the public by preventing real harm being caused to real people. Yet incidentally, one of the things I argue in my book is that the quality of discourse within the public sphere can be improved, and journalists themselves can, to an extent, be shielded from liability and also empowered by virtue of regulation and by virtue of the non-statutory incentives or services offered by the regulatory scheme that I advance. And these incentives include, amongst others, the fact that members of a regulatory scheme would be able to access training, education resources, law and policy updates, and also advice to help them to develop their journalistic practice or apply for funding, and also to understand and comply with the scheme standards code. And also, for instance, to provide them with a requisite level of knowledge to report appropriately on court proceedings, and therefore to avoid issues with contempt of court, for instance. This incentive would also help them to meet, for instance, the requirements of the Defamation Act 2013 defences, and also to comply with data protection law. And again, based on the research I've done around this and the work I've done with Impress, I know that this incentive is really attractive to citizen journalists who are very often unlikely to have ever had any formal journalistic or legal training and almost never have access to legal resources. Now, although not a complete shield, access to training, education and advice is likely to reduce members' risk of liability. And at the same time, members' engagement with these incentives indicates to the public that they're making every effort to operate professionally and within the law, and that they're trying to, insulate themselves from unnecessary litigation risks. Membership of the scheme would also bring reputational or brand advantages. It would demonstrate to the outside world that members are part of a group of media that place a high value on and have bound themselves to act responsibly. It says that they will abide by the concepts, standards of professional behaviour and norms of discourse, and are ultimately prepared to be accountable for their actions. So something akin to a kite mark would be awarded to members to enable them to demonstrate membership of and compliance with the scheme's standards. And what this will also do is enable anonymous and pseudonymous journalists to advertise their membership without having to be named. And this brings me on to the final incentive I just wanted to mention. Many citizen journalists choose to operate anonymously or under a pseudonym. To encourage membership of the scheme from these actors, because they are often so important to public discourse, and to ensure that they can continue to publish in this way, it would protect their anonymity and their pseudonymity so long as they adhere to its standards. And this protection would manifest in a number of different ways. So, for instance, these media actors wouldn't be named, or their pseudonym wouldn't be used on the regulator's website, correspondence, or in briefings or reports. And it would extend to any proceedings relating to alleged breaches of the code. Only in extreme cases, such as the event of breaches of the code amounting to criminal conduct, would the actors be named. So this means that anonymous and pseudonymous citizen journalists can not only join the scheme and take advantage of its incentives, safe in the knowledge that their identities are protected, but the audience will know that they are members of a scheme committed to responsible journalism by virtue of the kite mark I mentioned a few moments ago. So they're just some of the highlights. There are other incentives I go over in the book, but I am aware that I'm running out of time. I just wanted to very briefly mention, just in conclusion, my work with Impress. So as I've already mentioned, towards the beginning of this presentation, my book and my ongoing research has already made a significant impact on press regulation. A couple of years ago, Impress invited me to put together and chair an advisory group consisting of legal and communication policy academics, practicing lawyers and journalists to help with the development of a new regulatory scheme. And in particular, they wanted to develop a scheme that would not only be attractive to their existing membership, but would attract independent publishers and citizen journalists, and would effectively future-proof its regulatory offering for the foreseeable future. So the culmination of this work was my engagement by Impress to redraft its standards code and guidance, which I completed in January of this year. Now, this was a really challenging, but I have to say fascinating experience, and probably one of the most rewarding things I've ever done, that entailed working very closely with regulated and unregulated publishers and journalists of all shapes and sizes, different organizations, legal academics, practicing media lawyers, and researchers from various media related disciplines. It was just wonderful. I had a great time doing it, although it was rather stressful at times. Now, the new code and guidance is now subject to public consultation. And there's with a view to it coming into force later this year. And again, there's a link at the bottom, and if you follow that, you can engage with that public consultation process if you're interested in doing so. So just in conclusion then, what this work, the work leading up to my book, the book itself, and then the work I've done since then has made clear to me is that my book doesn't represent the end of my research in this area. Rather, I see it as the start. For me, it's already acted as it's already been a catalyst for more research and work in what is a fascinating and almost constantly changing area that continues to give me so much pleasure. I really hope you have enjoyed this presentation, the overview I've given you of my book and my research. Thank you all again so much for listening this evening, and I welcome any questions, comments, or feedback you may have.